The hearing will start now. This is originating application 381 to 385 of 2022, summonses 3866 to 3870 of 2023, Zipmex Company Ltd and other matters.
All right, good morning, Mr. Jonathan Tang and Ms. Charlene Wee for the applicants, correct?
Yes, Your Honor. Good morning.
Morning. All right, Mr. Justin Yip, Mr. Lam and Ms. Chiang for the fourth non-party in OA 382, correct?
Yes, I confirm that, Your Honor. Good
All
morning.
right. Good morning. Let me just check the other monitors. All right, I think assisting counsel can switch off your monitors if you wish to. Let me just administer the Zoom allocation first. So parties are reminded that there is to be no unauthorized photography or recording in any form and no dissemination of any photographs or recording of these proceedings, and only those counsel or persons notified to the court should be present at each location, and parties should treat these proceedings as they would a physical hearing. All right, Mr. Tang, Mr. Yip, thank you for your submissions being sent in earlier. This is the application for extension of time. All right, extension of moratorium. Mr. Tang, let's begin then.
Yes, Your Honor. Just as a very preliminary point, Your Honor, and as a matter of housekeeping, I think I need to update the court that at 10:10 a.m. this morning, Raja and Tan, who are the solicitors for the secured creditor, V Ventures, have written to us to say that they are taking no position in the application, at least in respect of the application for extension of moratorium for Zipmex Asia. Yes, if it pleases the court, I'll continue.
Yes.
Yes. So perhaps most pressingly, and first of all, I should start with an overview of the group restructuring, if I can still continue to call it that, as of this point. Your Honor is aware that our scheme has not passed muster at the scheme meeting and the voting period. So we are not making a sanction application, Your Honor. But in the course of the scheme process, Your Honor may recall that one of the facets for recovery was the sale by Zipmex Asia of its shares in Zipmex Indonesia and Zipmex Thailand, which are also two applicants before the court today. This was expected or anticipated to fetch around $6 million, which we have gone off towards paying V Ventures secured debt of $4.6 million, with the balance to be distributed to unsecured under the proposed scheme. As an update, and Your Honor will see from the affidavits and the submissions, Zipmex Thailand sale is relatively up in the air. It's not dead as of now, but it does not look incredibly likely at this stage. On the other hand, the sale of Zipmex Indonesia is very far advanced. And to illustrate this point, Your Honor, the sale consideration is $1,060,000. Of that sum, $60,000 has been prepaid. And in addition to that, the purchaser for Zipmex Indonesia has extended sums towards Zipmex Indonesia's working capital, which are not part of the sale consideration. What I mean is that earlier in December, what they did was remit $30,000 purely to be used for Zipmex Indonesia's working capital requirements. That's an indication of how serious they are about completing this transaction. They have also issued a letter, I mean, which was signed by them and countersigned by Marcus Lim and Zipmex Asia. And the letter shows that they are serious about completing this transaction, even though there may be delays on the completion status due to their internal audit and their internal due diligence requirements. So that's the lay of the land at this point. I should also highlight that the sale of Zipmex Indonesia for $1 million is potentially the best price that anybody would be able to obtain for the sale of these particular set of shares. It is secured, so the $1 million will go straight towards the fulfillment of V Ventures secured debt. That's the first thing. we say it is in the secured creditor's interest to help let this sale proceed. And also, it would be in the unsecured creditor's interest to let this sale proceed, because the reduction of the secured debt would correspondingly and potentially result in better distributions for every other unsecured creditor of Zipmex Asia. There is a deadline on this transaction. Bapepti regards it as the second mooted transaction of these shares in just over a year. So the first one, Your Honor, was to V Ventures itself, and that fell through in about April last year. So with what Zipmex Asia has done is gone to Bapepti and say, look, we intend to consummate this transaction at some point in time. And Bapepti has essentially said, okay, but do it by the 29th of February. It is not likely that they will entertain any other sale or any other proposed sale of this particular set of shares. The last thing to note as well is the possible repercussions if this sale does not proceed by 29th of February. So, as Your Honor knows, Bapepti has regulatory powers. It can suspend the license, it can pull the license. Indeed, this represents the last chance given by the regulator for a transfer of the ownership of these shares for value. Because if either the suspension or the pulling of the license occurs, this particular set of shares would lose any attractiveness to potential third-party buyers. So that concludes my attempt, Your Honor, to summarize the lay of the land for this particular application. If I may go on to address the court on the substantive moratorium extension itself. The key reason why we say the moratorium extension is required is to protect this particular transaction. Your Honor will see that I've emphasized it a lot in the written submissions. And essentially, the draft sale and purchase agreement for this particular transaction, would Your Honor require me to point you to the draft itself?
No, I think it will be quite obvious. Really, my concern is whether this falls within the ambit of Section 64 and the framework. I mean, I understand where you're going with this, but really, it's not about the restructuring, as you yourself has said in the submission. So, can it?
Yes, Your Honor. Maybe
Can it be ordered by the court? Is this a proper exercise of my powers, or should there be some other mechanism, or could it be that this is a gap that can't be fulfilled? Thank you.
Your Honor, if I may make some observations on this particular issue, I think what Your Honor is pointing at is whether Your Honor has a jurisdiction to make this particular order, right? I'm not trying to preempt my learned friend submissions, but I have put some thought into this, and these are my observations, Your Honor. The ability to grant moratorium relief under a Section 64(1) application, yes, it is premised on jurisdiction. It should be, and it's statutorily stated, and of course the cases have expanded on it, premised upon the existence of a restructuring or a proposed plan that is presented to creditors. I agree on that. That being said, Section 64(7) of the ERDA, which deals with the power of the court to grant extensions of the period, is disconnected from 64(1). Section 64(7) is a matter of the court's discretion, right? The question of whether the factors we have presented and we intend to present today, whether these are factors weighty enough to convince the court to exercise its discretion, is the matter before the court today. But reading 64(1) and 64(7), I believe that the court has the power to make the order or the orders that we are seeking. It is whether we can prove to the court that it is in the interest of creditors or it is in the interest of justice to grant the extension of the moratorium.
Mhm.
That is it from me, Your Honor, on the jurisdiction point.
Would you like to expand on your interpretation of the language?
I beg your
If-
pardon, Your Honor?
or one, would you like to expand on your interpretation of language in 64.1 and 64.7?
Of course,
Why does 64.7 give me that much leeway?
of course, Your Honor. Perhaps then I should bring the court to the relevant section itself, and that's tab 1 of the bundle of authorities,
Yes.
bound in red, Your Honor.
Yes, thank you.
Yes. So 64, Your Honor, if I may?
Yes, Karen.
Yes. So section 64.1 states where a company proposes or intends to propose a compromise or an arrangement, the court may make the moratorium orders that a company seeks, right? There are also statutory protections bound in at 64.3, which are the advertisement and notice requirements, and 64.4, which are statutory protections to ensure that before this initial application for moratorium relief comes before the court, all this information is set out, evidence of support, a brief description, a list of every secured creditor, and a list of all unsecured creditors.
Mm.
On the contrary, Your Honor, section 64.7 does not have these particular protections and is drafted to be much wider than 64.1. So section 64.7 says only that the court may make an order extending the period for which an order under subsection 1 is in force if an application for the extension of the period is made by the company before the expiry of the period. All that is required under 64.7 is that I make an application before the end of the moratorium. And we have done that, Your Honor. What
Carry on.
this shows is that 64.7 is a discretionary, it is to allow the court to exercise its discretion in a wide range of circumstances. And maybe if I can draw an analogy, Your Honor, it is very common after we obtain sanction for us to ask the court for extension of 2 weeks, 3 weeks, in order to extract the orders of court and file them with ACRA so the scheme goes into effect. At that particular stage, it is not a case where a scheme has been proposed. It's not the case where a scheme is intended to be proposed to the company's creditors, Your Honor.
But
The
that
scheme-
kind of case situation is where a scheme, it is still connected to a scheme. It's part of an implementation of a scheme.
It is, Your Honor, but that brings me back to my point. It is not a question of jurisdiction, it's a question of discretion. So the court has the power to make the orders. Whether the court should depends on the court's consideration of the factors.
All right, but supposing you persuade me on jurisdiction for the sake of argument, whether you classify jurisdiction or discretion, I'm not sure whether it really helps your case very much, because you seem to be saying that when it comes to 64.7, I have a very broad power and I can extend it even when no scheme is going to be viable at all or no scheme is actually being pursued, and really just protect a sale of the shares to protect the commercial position of the company, albeit or for the benefit of the creditors. What limits are there on the exercise of my discretion then? Is it so broad that I can grant an extension for almost any reason under the sun? Or what are the parameters of the exercise of my discretion?
It appears to me, unfortunate, Your Honor, that we seem to be in relatively uncharted territory here. The existing cases which both counsel have cited on the guidelines that the court should apply for the grant of moratorium extensions deal mainly with the preliminary stages of a section 21010 application before a scheme is presented, a 211B application, a 64.1 application in the case of Aquavus. So the guidelines that are out there have been laid down based on that particular factual matrix. So things like evidence of support by creditors for the proposed scheme, particulars of the scheme, the disclosure requirements, all that. They are all premised on the initial application for moratorium relief and whether that the automatic stay should be extended, right? In our case, we are in a little bit of uncharted territory simply because we are asking for relief at the end on the basis that, as Your Honor has pointed out, we believe this is in the best interest of creditors. We believe this is in the best interest of obtaining some recovery for various creditors of the group. Well, Your Honor has asked what are the parameters, and this is what we say and we submit, that the factors that should go in to Your Honor's consideration are threefold. We are looking at this stage at rationale, why we are doing this and why we are asking for an extension. We are looking at this stage at whether or not the company is seeking to avoid accountability to its creditors. And we are also looking at this stage at the question of prejudice. And on this, on these factors, it is always a weighing scale, Your Honor, on the balance as to whether or not an extension should be granted. I hope this answers Your Honor's question.
And of course, you have no authority for this. You're going on general principle.
I have scant authority for this, Your Honor. There is authority derived from what we see in Pacific Andes, what we see in John Schuber, what we see in Skaugen, right? But what I have done is to modify these principles, which I do not think are in dispute, but also to not disregard, but to put less weight on the factors, other factors that the court has considered in these particular cases, which I have cited, which is whether or not a scheme is ready to be proposed, how particular is the scheme, whether there's creditor support, for the extension of the moratorium and for the scheme generally. Those factors are not so relevant here. Yet, as Justice Ramesh said in Pacific Andes, whether the consideration of this particular application is also a multifactorial assessment. And we say that these are the factors that should go in at an application that is made at this stage.
All right. Could you flesh out how the parameters play out in this specific case that should lead to my exercising the discretion as you've prayed for? Yes,
Your Honor. So I have mentioned three factors earlier. Maybe I should go down them one by one. Right. So the first factor that I mentioned was the rationale for the extension. In our case, we are very clear that the rationale for the extension is to protect the transaction. Now, the draft sale and purchase agreement drafted by the purchaser's lawyers includes a group event of default on insolvency clause, the wording which Your Honor can find at paragraph 25 of our written submissions, Your Honor. So I've extracted it there for ease of reference.
Right.
So Your Honor will see, Your Honor, if I may.
Yes.
So Your Honor will see in clause 7.1e of the draft SPA that the purchaser has inserted a clause that says that the making of a bankruptcy, liquidation, or other analogous order against either party or its affiliates by a court of competent jurisdiction prior to the closing date is an event of default that will render the sale and purchase agreement terminable. And that's the reason why we are seeking an extension of moratorium for all the group companies. It is to protect these companies from the possibility of winding up. It's a very short extension. It's until the 7th of March, Your Honor. Because the deadline for that Papeti has set is 29th of February. And so we are seeking a very short extension. There are also other considerations why we are seeking these extensions for each of the group companies. For Zipmex Asia and Zipmex Indonesia, it's very clear. Zipmex Asia is the seller, and Zipmex Indonesia is the target company. So we want to protect those two companies until 7th of March, at least 29 February or 7th of March. Zipmex Australia is a group affiliate company. Your Honor has seen in the affidavit that there are plans to put it into CVL in Australia. That is anticipated to occur during the course of this extended moratorium. But crucially, it wouldn't be caught by this particular provision. Right?
Sorry, why wouldn't it be caught?
Because this particular provision says the making of an order by a court of competent jurisdiction.
So
Yeah.
creditors, all right.
So a voluntary winding up will not be caught. In terms of Zipmex Private Limited, one consideration is to assist the transaction. The other consideration and rationale that we have for seeking an application for extension of the moratorium for Zipmex Singapore is that there is a wind down plan already in place with the MAS. So Zipmex Singapore had applied for a PSA license, but during the course of the scheme proceedings, the director, Marcus Lim, was in contact with the MAS, basically to tell the MAS, look, we are winding down operations. The company may have to be kept alive after the scheme passes as a shell for recovery, but it doesn't intend to carry on operations, right? And so together with the MAS, a plan was formed on how to carry out this winding down so as to have the least negative impact on customers of the company. That's what the MAS is concerned about. So this wind down plan was proposed. And as a result of this wind down plan, in December, I think 1st of December, an announcement was made to all customers to say, look, we intend to shut down. Please withdraw all your balances by March 24. And now we intend to shut down the company conclusively by March 24. So the rationale for the extension of the moratorium is to allow Marcus to continue to oversee this process because he is the contact point with the MAS, right? And if a liquidator is appointed or a liquidator does come in during this interim period, he or she will also have to get up to speed with this particular facet and the communications with 80,000 or so creditors and even more customers than that, Your Honor, because creditors are only the Z wallet creditors. There will be even more customers of Zipmex Singapore. And that will unnecessarily incur costs in the liquidation. If I may?
Yes.
Yes. So the second factor which I had mentioned earlier was
Anything
whether
about Thailand? Anything about Thailand?
Oh, sorry. Your Honor, for Thailand, it's a little bit of a mixed bag because Thailand is governed and regulated by the Thai SEC. There's a process there. The last update I have is that the operations of Thailand are presently suspended, but they are working things through with the SEC. And that's the last update I have there. Again, any legal process comments against Thailand would have to be in Thailand under their winding up. And it is difficult for me to say more on that, Your Honor, because I don't have visibility over this process.
All right, but then the coverage of Zipmex Thailand would be on the basis that otherwise you would run afoul of your SPA clause. Would that be correct?
Yes, Your Honor.
All right, carry on.
Yes, Your Honor. The second factor that I had mentioned earlier that should go into the court's assessment is whether the company is seeking to evade accountability or to frustrate creditors from commencing proceedings. And Your Honor will recall that this was one of the reasons why in Pacific Andes, Justice Kanan Ramesh had cited these cases as part of the bona fides requirement. We say that this is not a case where we are seeking to evade accountability or to prevent creditors from taking adverse actions against the company. This is not a live company. Apologies, Your Honor. Zipmex Singapore is not a live company. Zipmex Asia is not. Basically, everything has been in stasis, Your Honor, since the deal from the previous investor fell through in about April. Much of the company's workforce has been laid off. We're operating on skeleton staff. And the only assets that still remain operational are Zipmex Thailand and Zipmex Indonesia. Zipmex Pte has evinced a very clear intention to wind down its operations. Zipmex Asia is basically just a holding company at this point. And the key to all this is in our elucidation in the affidavit of what each company intends to do in respect of next steps. We are not trying to delay this indefinitely. We are basically saying we want a very short extension until March 2024 to assist with the completion of the transaction, following which liquidators will be installed. And I think the main emphasis has to be on the final point. If any creditor is afeared that we will be doing actions in the interim to prejudice their interests, they can rest assured that there are stated intentions to place these companies into liquidation at the end of the extended moratorium period. And in fact, we will be working on the liquidation applications during the period of the extended moratorium. So we say that this is not a case where the company seeks to evade accountability or to frustrate creditors in the pursuit of their actions. And this is therefore a factor that should go into the cost assessment. The third, Your Honor, if I may go on to the third factor, which is prejudice. Your Honor, in terms of the prejudice argument, it mirrors what I said about the evasion of accountability that I mentioned earlier. We do not believe that there will be any prejudice suffered by creditors. First, it is a short extension of the moratorium. It's barely over 6 or 7 weeks, Your Honor. But most importantly, each of the companies has set out in the affidavit their plan moving forward. And for Zipmex Asia and Zipmex Pte at the least, there is the intention to install liquidators. And so creditors' interests should not be prejudiced during this particular extended moratorium period.
All right. Anything else?
One final point on the prejudice part, right? I just want to emphasize, Your Honor, that the company is no longer trading. The only expenses it continues to incur are the funds paid to service providers to keep the exchange running until March 24. And this is necessary because we've asked people to withdraw their balances from their wallets. And therefore, the platform needs to be kept open until then. There will be no prejudice occasion to any creditors because even if a liquidator is appointed, these costs will still have to be incurred. The liquidator can't just shut down the platform because the company has committed to the MAS, a third-party regulator, to go through this process. And so a liquidator coming in also would still have to oversee and incur this particular set of costs. That's all from me now, Your Honor.
Before I turn to Mr. Chin, are there no alternatives aside from section 64(7) for you?
At this point, well, I mean, we did brainstorm this, Your Honor, to be honest. For Zipmex Asia, Zipmex Pte, and Zipmex Australia, my understanding, at least of my reading of the scheme document, the original sanction prepackaged scheme is that it is still in effect, even though it is not capable of being carried out because the investor has pulled out. But for us to rely on that is not something that we wish to do in good faith, because it is very clear to everybody that the investment can no longer be completed. We just haven't terminated the schemes of arrangement. Plus, this only protects Asia, PTE, and Australia. It doesn't protect Indonesia, nor does it protect Thailand, because no prepackaged schemes will enter into for these two companies. So that option is out. Whether we can alternatively try to fight off actions as and when they are threatened, to basically say to petitioning creditors or to potential claimants that could you please hold off until 29th of February or 7th of March, which is the other alternative, would require much cost to be incurred, first of all. And there is inherent uncertainty in that particular course of action as well, because it depends on the goodwill of these claimants and petitioning creditors to hold their hands until 29th of February or 7th of March. And that's not ideal, in our view.
Right. So in some situations, we do have companies that may be perceived to be vulnerable to liquidation proceedings, applying to the court for essentially protective injunctions preemptively to stop creditors from filing petitions. Could you not do something of that nature?
We could, but at the same time, Your Honor, there's also that cost effectiveness argument on that. I do believe these applications will be expensive. And for us, on our reading of the ERDA, if it was possible to extend or to apply to extend the moratorium, we should look at that as the first port of call, and to throw ourselves upon the court's discretion as to whether such extension should be granted.
Would you be able to take a position about whether any such injunction will have some possibility of binding persons subject to the jurisdiction of the court, even in relation to actions outside Singapore?
Yes, Your Honor. So that was the second consideration which I was going to raise. Right. I am not clear at this point, and I need to go and read up on whether these injunctions can be taken to bind persons outside of Singapore. Right.
Not persons outside Singapore, but persons subject to the jurisdiction of the court, but who may be, whether they can be enjoined from taking actions outside our territory.
I think it's a stretch. But again, Your Honor, I'm not in a position to state figuratively or conclusively whether that is the case in such injunctions.
All right.
That being said, the moratorium, again, Your Honor, going back to the moratorium, we had asked that these moratoria have extraterritorial effect.
Yes.
Yes, and therefore, again, applying for extensions of the moratoria seemed to be the path of least resistance in terms of getting the effective relief that we are seeking.
All right, I do still have some concerns about jurisdiction and the extent of any discretion that exists. But all right, let me turn to Mr. Chin first. Chin? Sorry, Mr. Yip. Sorry, Mr. Yip.
That's right, Your Honor. I was just checking to make sure there wasn't another counsel in the room.
I had Mr. Justin Chin for something else. Right, carry on, please.
Obliged, Your Honor. As my learned friend has kindly introduced us, I act for Mr. Richard Chua Fen Ping. He's a creditor of Zipmex Private Limited.
Yes.
And also the fourth non-party in OS 382.
Yes.
Your Honor, as my learned friend has already sort of summarized a lot of the key facts, I will jump from that, I think what is not in dispute is my client's a creditor of Zipmex Private Limited. What's not in dispute is that there is no Zipmex Singapore scheme being proposed or intended to be proposed. What's also not in dispute is that Zipmex Singapore's evidence admits that there is no restructuring prospect and that liquidation of Zipmex Singapore is imminent. Your Honor, and allow me to clarify. I appreciate that there's 5 applications before Your Honor today.
Yes.
For 5 entities. My client is only a creditor of one of the entities, Zipmex Private Limited. For ease of reference, I think the definition that's commonly being used in the court papers is Zipmex Singapore, so we'll continue to use that. He's not a creditor of the other 4. We take no position on the other 4 proceedings. Now, as Your Honor has actually kindly pointed out, there is a gap, and our difficulty is first and foremost a jurisdiction point. This is an application by Zipmex Singapore, in our case, under 64 subsection 7 of ERDA. And it's an extension of the scheme moratorium, first order in 64.1. We don't have to look at the cases, Your Honor. The provision is clear. It is elemental in 64.1 that a scheme is proposed or intends to be proposed. It is by its nature a scheme moratorium. There is nothing in legislation or in case law that allows the court to grant a 64.7 moratorium extension for anything else than when a scheme is proposed or being proposed. I think Your Honor is alive to that and has pointed out other possibilities. But insofar as the application today still pertains to 64.7, it's our position that there is no scheme proposed. And therefore, on that alone, the application has to fail. It's legally flawed, and the court has no jurisdiction to hear it or grant the order. Because put it in its simple terms, Your Honor, the applicants at Zipmex Singapore is asking you to protect, well, in the first instance, sale of shares, but the sale of shares of another company, Your Honor. It's worth pointing out that these shares being said are Zipmex Indonesian shares, Zipmex Thailand shares, and these shares are owned by Zipmex Asia in part. I think the shareholding is also owned by Mr. Marcus Lim. But they are not assets of Zipmex Singapore, the company which my client is a creditor of. My client gets no benefit from this sale. And to then impose, or for the court to impose protection for Zipmex Asia, assuming if Your Honor even considers that he has jurisdiction, to impose protection for Zipmex Asia's transactions for the benefit of Zipmex Asia and its creditors at the account or at the cost of Zipmex Singapore's creditors, Your Honor, I would say that's unprecedented and incorrect. It's a different situation, Your Honor, if let's say the second scheme had succeeded and there were proceeds being shared amongst the 2 companies, as I understood the second scheme's design intent to be. But that's not the case right now. So we simply have 2 separate legal entities with 2 different baskets of creditors with 2 different sets of interests. So I mean, on the jurisdiction point, with no scheme being proposed and that being the bedrock, and I understand my learned friend has argued that 64.7 is disconnected from 64.1, and the court has a discretion, untethered to 64.1 to grant an extension of a moratorium, irrespective of the conditionalities of 64.1. I respectfully disagree, Your Honor, on that. I think that they're all part of the same 64 provision, and it's abundantly clear in 64.7 that it is an extension of 64.1. Must be read together. And actually, Your Honor, in 64.2, as Your Honor will be aware, there is an obligation, there's an undertaking to be made by the applicant that they have to file either a 210(1) application or a scheme sanction application. Those must follow. It's a different story if a third scheme was intended to be proposed, but that's not the case here. I mean, the applicant's candor is appreciated. There is no scheme being proposed in this case. So that's, in a sense, legally, that's our primary difficulty, that this just it's not permissible. And you know, if case authority has to be relied on, I think it's very easy to just turn to Your Honour's case in Aquaverse. That was a bang-on-point case where Your Honour was looking at an extension of a scheme moratorium, and Your Honour applied the same Pacific Andes and Skaugen test, you know, looking at the reasonable prospects of a scheme being proposed. You know, I mean, we often look at a part about it being, you know, acceptable to a general run of creditors, but the first element of that test is a scheme has to be proposed. So whether it's the provisions or whether it's cases that interpret it, I think we can't get around this. And so we say on that alone, Your Honour, the application must fall. I'm happy to continue on my submissions, Your Honour, on the assumption that Your Honour so decides that you have jurisdiction. But I wonder if Your Honour would like me to pause for a moment right now on this point.
Yeah, yes. I mean, it's something I have to ponder, and I will probably grant a short interim extension, at least until I can put together some remarks by next week. But I'm still thinking about the question of jurisdiction and discretion. I'm afraid the arguments a bit of a stretch, Mr. Tang, but anyway, I'll come back to you in a short while. I understand the commercial imperatives, but I do wonder whether the framework allows it. But in any event, Mr. Yip,
I'm happy, Your Honour, to go through very briefly
just very
our
quickly,
responses on the
is
grounds.
your client actually going to file a liquidation application tomorrow, say, if I don't grant the moratorium extension today?
Well, strictly speaking, Your Honour, your moratorium as for the last order expires on Monday,
On Monday,
unless
right.
Your Honour is prepared to lift it.
Yes.
So you know,
All right,
if
let's say
my
not
client,
Monday, but Tuesday. Is your client going to file on Tuesday then?
I can confirm that my client's considering it.
Consider.
Yeah, I mean, if Your Honour so directs the applicant to file, that sort of changes the complexion.
No, it's not so much that I'm considering compelling it or directing anyone to file, but I just want to know what the current intentions are of your client. And is he raring to go on a liquidation, or is he just considering at this time?
No, I think it's fair to say that my client, as a lot of these creditors, I understand, you know, are keen to have at least Zipmex Singapore. I can only speak for my client. Zipmex Singapore placed into liquidation. Ideally, with a liquidator appointed with the, you know, the blessings and consent of the creditor body. 1.5 years have passed, Your Honour. You know, the management has had their chance with 2 schemes. Now that there is no further schemes to be proposed, it's important, I think, that the liquidator come in. And you know, if you look through all the grounds that Zipmex Singapore has raised, or rather the Zipmex entities have raised, a lot of the grounds are on Zipmex Asia side, which again, I stress, is not Zipmex Singapore. And if you scrub all the other points that are irrelevant just down to the Zipmex Singapore point, it only turns on, well, one point, that it is more convenient and it saves time, it saves cost for management to be in play. Your Honour, I don't necessarily agree as well. It's a company that's not live. It's not got a license. Unless there's evidence that MES is prohibiting, you know, the company from winding up, I can't see why a liquidator can't do the same things at the same cost as management. It doesn't save costs. Management will incur the same cost as a liquidator would do, and it will still come out of the creditor's pockets.
All right.
And I don't agree that there's no prejudice. There's prejudice of time and opportunity, not least 2 months lapsing, potentially allowing some potential clawbacks to slip away. You know, when we are at the stage that a company is insolvent and there's really no assets to sell, I see it as the director's responsibility that a company be put in liquidation sooner than later. So I don't agree that there is no prejudice in that sense. And the point that I understand put in place about the clause in the sale agreement, that's you know, it's not our point. It's Zipmex Asia's point. I mean, we didn't ask for it to be there. We shouldn't be prejudiced just because it's there. And it's a draft agreement. It's not finalized. How do we know that it's not going to be negotiated out after this hearing? How do we know it can't be repriced? I don't understand, for example, how I think the evidence is that Zipmex Australia was allowed to be in voluntary liquidation. Well, they could have put Zipmex Singapore into voluntary liquidation as well, and then it wouldn't trigger this. And the reasons piling on as to why they are resistant, I think only fuels our client's desire to just have this put in the hands of an independent court-appointed trustee and to look into the scenario.
All right.
So if we had to go into the grounds, Your Honor, and this is also spelled out in our submissions, we don't think that the grounds, most of the grounds as stated, because it's a consolidated application, it don't apply to us. The one ground that really, in a sense, if it all applies to us, is the convenience point or the orderly disposal point, and I don't see how a liquidator can't do this as well. And actually, with more accountability, by my learned friend's submission about accountability, I think the accountability would be the best if a liquidator is in place with the court supervision.
Right, thank you, Mr. Yip. Anything else?
No, Your Honor. I mean, I briefly went through the grounds points, but I'll be guided by Your Honor if Your Honor requires
No,
our further assistance.
Feel free to raise anything else, or if you want to summarize the rest of your submissions.
No, Your Honor. I think I would I think the submissions is deemed read. It's just another, I mean, really more on the point on the clause, because that was given to us yesterday, the SPA Indonesian clause. Just a few legal points, Your Honor. The draft is governed by Indonesian law. The term affiliate, which is in the clause, is not defined. And I think my learned friend's argument or Zipmex Singapore's arguments is that basically it should be logically read to include Zipmex Singapore. I don't necessarily think that we can jump to that conclusion without Indon legal advice. So that's, in our view, something that that can't be supported. No, I mean, that's just the additional point on the clause, which was really the last point that we couldn't have addressed in our submissions that was filed just an hour or so after that.
All right. Thank you.
And Your Honor, lastly, I think in the affidavit of the draft affidavit of Mr. Marcus Lim, the fourth draft affidavit, which was included in Ms. Charlene Wee's affidavit of 4th Jan, the one that filed yesterday, where this point about the clause was in, I believe that there was quite a long tail told from paragraph 16 to 21 about 16 to 21 to 36, I think, of the paragraphs, about my client's background, which school he went to, who his wife is, what company she owns, when they sold whatever tokens. I don't understand. Well, I have no time to take instructions on that. I don't understand my learned friend to be making any point or drawing any conclusion from those. So I likewise do not see a need to respond substantively on them, unless say that we're reserving our rights to deal with those allegations at a later stage or insinuations.
All right.
Yeah. That's all on my end, Your Honor.
All right, thank you. I had asked Tang about alternatives, but I will not ask you. I don't think it'll be fair, since it's a bit harder for you to respond to these alternatives.
Well, if you ask my clients, Your Honor, I think we only have one alternative.
All right, never mind then. All right, thank you, Mr. Yip. Let me turn back to Mr. Tang.
Pleasure, Your Honor.
All right, Mr. Tang.
Yes, Your Honor, if it pleases the court.
Yes.
So there are just one or two things that would compel me to make any response submissions to my learned friend's oral submissions.
Mm.
First, I want to go back to the point, Your Honor, that and Your Honor had raised this earlier. Whether there is a plan by my learned friend's client to file any winding up operation, any winding up application against the company. Mr. Chua has not submitted an affidavit. Whether it was too late, he did not have the opportunity to, I do not know. But as it stands now, all my learned friend can say is that his client is considering filing an application. And we say that the extension of the moratorium is for a little over 7-8 weeks. There will be no prejudice occasion. Mr. Chua has not evinced an intention or any urgent need to file or to place a company into liquidation as soon as possible. And there will be no prejudice occasion to him or any other creditor or Zipmex Singapore if the moratorium is extended accordingly, especially in the case where we ourselves have committed to placing the company in liquidation or appointing liquidators over the company at the end of the extended moratorium. In terms of the draft SPA, I mean, our apologies that it was sent so late. I appreciate my learned friend's difficulty on this. We also have, I take my learned friend's point on the definition of affiliate under Indonesian law. If necessary, we can adduce further evidence to that point, or we can take Indonesian law advice. It has been said in the affidavit, and it's also my reading, that affiliate should encompass the Indonesian subsidiary, sister companies, and parent. It seems to be the logical reading. But I take my learned friend's point that we cannot definitively say so without the benefit of Indonesian law advice. I agree on that. Just very quickly on the alternatives, Your Honor, just looking through what we have seen so far about injunctions against winding up, they are against targeted creditors who have applied. So for companies to be wound up. And again, Your Honor, this goes back to the reactivity of such applications. An injunction can be filed. Yes, it's an alternative. We can apply to injunct people from winding up the company or to stay current winding up actions against the company, but it's reactive. It's not against the world, and it does not bind the world. Which is why we had applied to extend the moratorium accordingly.
All right.
Yes. That, unless I may be of further assistance, Your Honor, that concludes my submissions.
All right, Mr. Tang, would you be able to say anything about the matters in your client's fourth affidavit, sorry. What Mr. Yip has referred to as insinuations or allegations?
So I don't agree that these are insinuations or allegations. The reason for this is because when we receive the email from my learned friend's firm informing us that they have been appointed to file submissions and raise this objection at the hearing, we were aware that we will be going into this hearing without the court having any kind of background on this particular creditor. Because in the normal course of events, Your Honor, this creditor would have filed an affidavit placing before the court who he is, his debt value, and his reasons for the objection. This is a creditor that is connected to the company in multiple ways. His wife owns a company which is a shareholder of Zipmex Asia. Whether or not that is a factor which goes towards the connection grounds for avoidance of transactions, we are not sure, but we needed to put it out there that this is his relationship with the company.
All right.
In terms of
primarily for background then.
It's mainly for background, Your Honor. The same goes for the paragraphs that state in relation to Plum and in relation to Crowd as well. It's all for background and for the court's reference if necessary.
All right. So, Mr. Yip, I will leave it at that you can take your client's instructions. Then, if there's anything further to be pursued in relation to the affidavit, we can deal with that later, I suspect.
I understand, Your Honor. Obliged.
All right. So thank you, Mr. Tang, Mr. Yip. As I said, I'll need to ponder a bit. I still have some concerns, but I think given the novelty of your application, Mr. Tang, it would perhaps be best for me to try to put together some remarks and to really weigh the weight of your arguments and see how it fits in with the structure of the Act. And I'll also consider what alternatives might be open for me aside from that in any event. So I will take just a little while to consider my decision. Won't be for too long, so I will reserve this for judgment, sorry, for decision. Let's again not to do too, not to stretch it for too long. Let's stay. All right. Right. I will aim to do this. I'll give my decision on Thursday, the 11th of January at 5:15 p.m. All right, so I'll give my decision then. All right. Anything further, Mr. Tang?
Your Honor, would the moratorium be extended until
No,
Thursday?
sorry, interim extension until the 11th of January. All right, just to cover the time I reserved. All right, anything further, Mr. Tang?
Nothing from me, Your Honor.
All right, thank you. Also, all moratoria in force are extended to the 11th of January in the interim. Mr. Yip, anything further?
No, Your Honor. I guess just administrative matter. Is Your Honor going to also ask if any of the other creditors have any views, or is this going to be also reserved till next Thursday?
Only those have argued today. I only have you as arguing this afternoon. I don't seem to have anyone else. No one else has filed anything. All right.
Right. Obliged.
All right. So I'll give my decision on the 11th of January, 5:15 p.m.
Grateful, Your Honor. Much obliged.
All right. Thank you.
Good day, Your Honor.
Obliged.
All right.
Good
Thank
day.
you. Court is adjourned. Thank you.
Court is adjourned.